Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome to our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is What Makes a Maverick? Merger Analysis and Competitive Disruptors. The 2010 FTC DOJ Horizontal Merger Guidelines indicate that the agency's merger review will consider the disruptive role of a merging party. That is to say, whether a merger may lessen competition by eliminating a maverick firm that plays a disruptive role in the market to the benefit of consumers with a new technology or business model. But how do we know when a proposed merger involves such a maverick? In today's episode, we're talking to Baker Botts partner Taylor Owings about the maverick concept and what she thinks should be the defining features of maverick firms for the purposes of merger analysis. Welcome to our Curious Amalgam, Taylor Owings.
Hi, Alicia. Thanks so much for having me. It's great to be here.
My co-host today is Matt Reynolds. Hi, Matt.
Hi. Thanks for having me.
Now, just to get a little bit of background on you, Taylor, from 2018 to 2021, you were the counsel and chief of staff in the Antitrust Division of the U.S. Department of Justice. What did you do in that role?
Well, that was a real highlight of my career, getting to serve at the Department of Justice. So when I started in the role of counsel in 2018, I was an advisor to the Assistant Attorney General at that time, Macon Delrahim. And the job description is a little bit jack of all trades. It's whatever are the priorities, largest cases, biggest policy initiatives of the day. That's what's on your plate that day. And so when I started in 2018, the thing that was taking up the most bandwidth and the thing that was on everyone's mind was challenging the AT&T Time Warner deal. And so that is what I went to work on right away. And from there, the job evolved as the matters evolved. And eventually I served as chief of staff starting in 2020. And that role really is the bird's eye view of the entire division and making sure that all the trains run on time.
And before that, though, tell us a little bit about your career path. Did you go straight from college to law school?
No, I actually didn't know at all in college that I was destined to be a lawyer. For me, college was all about economics. I in high school had read the book Freakonomics, which listeners may recall was kind of this groundbreaking take on pop economics. It made economics interesting to the lay observer, and I was hooked and knew that I wanted to study economics in college. That was my obsession, really. And I had never heard of antitrust at the time. So I didn't know really that law and economics had any overlap. So after college, I was seeking to find a job where I could practice economics and solve problems day to day. And it was only when I was getting my master's degree in regulation from the London School of Economics that I took a course on antitrust law and saw the overlap and immediately knew that was my calling.
That's great. Thanks so much for that little bit of background. Matt, this episode topic was your idea. What's so interesting about Mavericks?
Well, I was thinking a bit about Mavericks and not really related to the Top Gun movie or the late Senator John McCain, but rather to, as we all know, the antitrust concept. This is an issue that comes up obviously in merger analysis. By way of example, the JetBlue Spirit merger, I think has some what we're going to talk about today and some aspects that might come into play with respect to that. And so I was thinking about Mavericks, and I happened upon Taylor's law school note, actually. And so I thought we could start our discussion with Taylor there today with your law school note. For those of you who are Blue Book enthusiasts, it's 66 Vanderbilt Law Review 323 from 2013. Taylor, could you tell us a little bit, what was the genesis of this note? How did you come to pick the topic of Mavericks as a topic for your note?
Well, they say write what you know. And I think that's never more true than when you're trying to figure out a law school note topic. And the reality is that I had served between college and my master's degree program as a business strategy consultant at a firm that was then called Insight. It's been through various changes and acquisitions since I worked there. But at the time it was called Insight. And the idea behind Insight was that it was the consulting arm of Professor Clayton Christensen's body of work. So Clayton Christensen is was a Harvard Business School professor. He sadly passed away not long ago, but he was the extremely charismatic and famous business school professor who came up with the idea of disruptive innovation. And he wrote a seminal work called The Innovator's Dilemma that described what disruptive innovation was and applied it to lots of business scenarios really throughout the history of American business since the Industrial Revolution. And the job that I had as a business strategy consultant at Insight was to apply the theories that Clayton Christensen had written about in an academic setting to the situations that companies were facing today. So we would be hired to figure out an innovation strategy for a company, to sometimes to assess what a company's competitors were doing that might be in the vein of disruptive innovation and how to respond. And those experiences and having that academic theory really ingrained in my experience caused me to realize that there was a lot of similarities between the analysis that I was doing as a business strategy consultant and the analysis that antitrust enforcers seem to do about what made competitors special.
Interesting. The title of your note is Identifying a Maverick When Antitrust Law Should Protect a Low-Cost Competitor. And I was curious if you could talk a little bit about how that aspect, low-cost competitor, plays into what I think your note tries to define a maverick to be.
Yeah, absolutely. This goes back again to Clayton Christensen's theory. I want to make sure I attribute this is directly from him. So in his view of disruptive innovation, there are two types of competition when it comes to innovation. There's competitive innovation that advances along a vector that everybody is already used to seeing product improvements. So technologies are chip technologies and computers are getting smaller and faster, right? This is a vector that everybody knows is a product improvement. That's not a disruptive innovation. That's just regular innovation in this framework. Disruptive innovation is where a competitor chooses not to engage in that primary vector of improving the product, but rather innovates along some other vector, typically in a way that is going to make the product worse along the typical vector of competition. So to use a somewhat absurd example, it would be making a computer chip that is bigger and slower, right? It would seem to be a worse product by the metrics that the typical competitors are competing. The incumbent competitors is what we usually call those. The key, though, is that by giving up along that dimension of competition that everybody's used to, the competition taking place, you can gain something along another vector of competition. So many times you make a worse product for a lower price, and the lower cost is the vector on which you're succeeding. But there are other examples of sort of orthogonal vectors of competition where you're making a worse product but achieving something new for a niche group that will choose your product when they wouldn't have been interested in the really high performing product.
Yeah, I think of an example like during the pandemic, our children were all issued Chromebooks by their schools, which is something that they occasionally used in the classroom, but obviously with remote learning, it became a necessity. And I think of, when I think of Chromebooks, I think of that maybe being an example of what you're talking about, where it's a product where, they're aimed at getting to a lower cost by having, processors that are much slower and much less complex than what you might find in a regular, Office PC, for example.
Yeah, that's a fantastic example. It opens up the market for kids, basically. It opens up a new consumer niche by really going down market, right? Giving up on the performance that we're typically used to seeing competitors compete along. Another example that I give in my student note that I think is intuitively helpful for folks is when Netflix was introduced. We were all used to going and getting our videos, our rental videos from Blockbuster or Hollywood Video. And the typical dimension of competition we were used to was video selection and immediate satisfaction of demand, right? The question was, were you going to be able to see that video that just came to be released? Were you going to be able to see it that Friday night? If you walked into the store, would they have a wall full of those videos so you would definitely be able to see it right then? And Netflix, when it first debuted, was not the streaming on-demand video service that we all know and love now. It was a mail orders service, and it totally gave up on that competition for immediate satisfaction of demand. Instead, it was all about figuring out recommendations. It was about the algorithm and figuring out a movie experience that you and you alone would uniquely love. And it offered something else too, convenience of not even having to travel to the rental store. You could just receive the movie in its mail, in your mail. And so that sort of tilting on its side, the vector of competition, is really what being a disruptive competitor is about. And I think in some antitrust cases, it's what being a maverick is about.
No, that is great. One of the things that struck me about your note is that you lay out sort of in the early sections that, at least as of the writing of that piece, there really wasn't a clear, accepted, authoritative definition of Maverick with respect to either of the two antitrust agencies. Can you give us some insight? How has that changed over time? It's obviously been about 9 years since your note. What can you say has changed, or is it still kind of in that state of play?
Yeah, it's a great question. And I think it's really timely right now, actually, because I think that the use of the term of art, if you will, Maverick, in the 2010 Horizontal Merger Guidelines is sort of a cautionary tale for what it seems like the FTC and DOJ may currently be embarking on a mission to do, which is to create a framework or a guide for analysis that's based on theories that haven't necessarily been tested in court, or really using terms that haven't been given a definition that courts understand or can get behind. And I think that the use of the term maverick in the 2010 Horizontal Guidelines really shows that it's well and good to put a fancy word into the guidelines, but if a court doesn't understand what test it must apply to decide that something is a maverick, then you're a little bit up a creek without a paddle. And that is, in fact, what happened when the DOJ litigated a case relying a fair amount on the contention that the target company was a maverick. This case was H&R Block Tax Act. And the DOJ was ultimately successful in this case, but it won on a unique or on a different theory, not its maverick theory of harm. And the court somewhat admonished the DOJ in its opinion that it had no idea, despite, quote, substantial ink spilled, it had no idea what a maverick was. And it seemed to the court like a maverick was just a rigorous competitor, like you would expect every company to be. And so that opinion came out right before I began writing the note, and it struck me as an opportunity to offer a more precise definition of the term that might square up with the analytical approach that DOJ seems to be taking in that case.
And it sounds like your consulting background actually made you very well situated to speak to that issue, even as a law school student still.
Well, again, write what you know. I mean, I certainly didn't know merger review and merger trials well, but I did know how to break down an analysis of whether a competitor firm was special in any way, was unique and provided a unique competitive role.
So if you could share with us, what was the definition that you proposed in your note? And then I guess you can speak to whether or not you still stand by that definition, or if your experience, including your recent experience at the Department of Justice, has informed that or updated that or made you think about changing it in some way.
Sure. So drawing on H&R Block and Tax Act, as well as at that time the challenge to block AT&T T-Mobile, it seemed to me like one of the goals that the DOJ and FTC ought to adopt is defining maverick in such a way that it was clear to a court that the status of the competitor would be materially different post-merger. So you can have a special disruptive innovator at time one before the merger, but the question really is whether that special disruptive innovator is going to maintain its special sauce post-merger. And the theory that Clayton Christensen laid out in The Innovator's Dilemma explains that there are some good reasons why you ought to be skeptical of a disruptive innovator being able to be acquired into a traditional incumbent firm. And the reason is that in incumbent competition, remember we talked before about competing along the traditional vectors, all the management systems are set up to reward performance along those traditional vectors. The key performance indicators, stock price trends, and analyst forecasts are all based off of these the question of whether you're really performing along the traditional innovative vectors. And as a result, it becomes really difficult to ask one of those traditional innovators to take on the mindset of a disruptive innovator and start failing along those key performance indicators. And so when you see a mismatch between an incumbent that has ingrained in its culture and its management culture, these key performance indicators along which the disruptive innovator would be totally failing, you might start to be suspicious that post-merger, you're not going to maintain that same disruptive, innovative power.
And have there been any recent examples of courts or folks from the agencies in recent years sort of endorsing or taking on that definition? Has that made headway in any vectors that you can identify?
I wish that I could report that this student note, set the world on fire, started an antitrust revolution, and that we're living in a totally different world today than before. But this was not that student note. So I will offer a couple of observations. No one has really gone quite as hard in terms of really dedicating themselves to the definition of a maverick since that H&R Block Tax Act case, and you can understand why. Again, the judge was not shy saying that this didn't work, so it makes sense that we wouldn't have seen kind of another attempt by the agencies or any more really detailed explanation from a court. However, it's clear to me that the basic analysis and the temptation to look at cases in this way has survived and is still sort of alive and doing well. And one case that I just think is the most perfect example of this, and it actually sort of makes me laugh, because the industry is so prominently featured in a lot of the literature that Clayton Christensen put out. It's the razors cases that the FTC brought a few years ago. So that's Harry's Edgewell and P&G Billy. Razors are another prototypical example of disruptive innovation. The way that Clayton Christensen always put it is, we're so used to seeing Gillette or the incumbents compete along the vector of more razor blades, right? First, it's the Trio, then it's the Quattro, then it's the 5-blade razor. And it's like, how many more blades can we put on the razor and people will still consider this a product improvement? And so it's an example about how traditional vectors of competition sometimes run out, and disruptors are able to, competing along a different vector, make headway, get a foothold, and then eventually kind of come for the incumbent's lunch. And that is exactly the theory that the FTC articulated in Harry's Edgewell and P&G Billy. They identified those direct-to-consumer razor companies as being disruptive innovators who would both disrupt the ability of a consolidated industry to coordinate, and also would be sort of unilateral forces for innovation. So that, to me, is an example of where the concept of a maverick and maybe even the overlap between the definition of a maverick and the definition of a disruptive innovator would have come into the spotlight had the case been adjudicated. Of course, the parties abandoned.
So I guess we'll have to postpone judgment to another day on that front. One of the other examples, you mentioned the example of razors. One of the examples that I thought of that led me to want to speak with you on our program today, when looking at your note, was an example of airlines. And in particular, I thought of the JetBlue Spirit merger. I don't know if you've ever had the pleasure of flying Spirit Airlines before. I've actually flown it a couple of times with my family. But what's interesting is if you look in the press, industry press, popular press, Spirit, tends to get a bad rap. I mean, it's described as, there was an article in Chicago Booth Review, why Spirit Airlines is so terrible. Consumer Reports has ranked it in the past the worst airline in America. You'll find, on the other hand, you'll find travel bloggers who write, in-depth reviews of why flying on Spirit wasn't so bad, or they'll talk about how they got an incredible deal. They flew, coast to coast for $35. It struck me as I was looking at your article, and especially at the definition that it laid out, that, Spirit Airlines, at least as I was reading your article in the definition, seems like it might tick some of those boxes of what might be considered a maverick, even though it's in an industry that's a pretty mature industry. And, a lot of folks think it doesn't have a whole lot of innovation going on. They do have a fundamentally different approach to how they book. Obviously, they advertise very low fares. I don't know if you've had any occasion to read anything about them, but I was curious to get your sense, looking at them, is this a situation where potentially a maverick analysis might come into play if there is any review or scrutiny of that merger?
It's a great question, and I think you are exactly right to be asking it and wondering if it applies in this merger. I think one thing I've learned since writing the note is that there's a lot more on this question that can be answered, I think, with in-depth investigation into the facts than I was aware of at the time. I think, being a strategy consultant at the time, that was, the only sort of work experience I had then. And I think I was used to doing sort of 10,000 foot level analysis, the kind of parachute in, assess what's going on based on some basic facts and come up with a diagnosis. I think that there is a lot that could be ferreted out in an investigation about what the incumbent and the target are actually using, for instance, as key performance indicators, what they're managing to. And that would really help answer the question whether Spirit is really so different from JetBlue. It's certainly the case that popular opinion would say that these are two different kinds of experiences. And exactly like you say, it seems like that Spirit's model is to capture a new niche of consumers by giving up along the key performance vectors that we're used to seeing airlines compete in, for instance, customer service and a pleasant flying experience. It certainly seems like they're capturing a new group of consumers. But I wonder whether the fit would really be so bad between a Spirit and a JetBlue. And I think the answer would be contained in business documents, basically. What are they? Are they? Is Spirit struggling to become more like a full service airline? I don't know the answer to that question, but I suspect that it is contained in those ordinary course documents.
Well, great. Well, that's really been a fascinating discussion of this topic. Appreciate your time on this and joining us on the program. I think at this point, Alicia is going to observe one of our traditions and talk with you a little bit about your personal interests and things like that.
That's right. And for those of you listening, we always post some relevant materials on every episode webpage. So I expect for this one, I'm hoping we'll get a link to Taylor's note, to the cases that she talked about, and to what I recall was a Saturday Night Live skit that had to do with 10, 12, 14 razor blades. I have to go back. I'll have to do
I'm not aware of that. I love it.
I'll have to do some YouTube research. Yeah, okay. So I'm not crazy. It exists? Okay.
There's also an article, I think, from the Onion satire newspaper, the title of which I won't repeat here because it has an expletive in it, if I remember correctly. So, but maybe we can include that one too. We'll see.
Okay. What we do with every guest in order to get to know them a little bit better as human beings is to ask them, what is something interesting about yourself that is outside of your professional life?
Yeah, so it is sort of hard to diagnose what's interesting about yourself because you just live your own life. But I think that what I would want someone to know about me upon meeting me is that I'm a board game enthusiast, because if that person plays board games, then I want to invite them over and play with them. So I think that for people who, especially who are interested in economics and antitrust, there's a really amazing parallel in a lot of board games. There are interesting decisions to make. There's kind of a psychology of trying to figure out what your opponent is going to do before they do it. And there are even some games that involve auction mechanics for those IO enthusiasts out there.
So what's your favorite game? Monopoly?
Definitely not Monopoly for many reasons. No, there's a real revolution right now, actually, of modern board games being released on Kickstarter and being popularized through word of mouth. And the amount of creativity and the joy that it is to be someone interested in board games right now is amazing. I would say some of my favorites include Cyclades, which is a set in a Greek island chain, and you have to bid. Like I said, it's an auction mechanic. You have to bid for the favor of certain Greek gods in order to accomplish your goals. And then another one that I think is sort of amusing to economists and antitrust lawyers out there is one called Power Grid, where anybody who's oil and gas energy specialist would love building out their power grid.
Those are great. I'll have to check them out. So the final segment involves a quick little game. We call it the Curious Hat.
And now it's time for the Curious Hat.
The rules are very simple. All you need to do is imagine that I'm holding a hat and that I'm going to pull a number out of that hat between 1 and 10. So tell us what number I've just pulled out of the imaginary hat.
Number 4.
4. All right. The question that goes with this. This is your surprise question. What has surprised you most about your career so far?
That's a great question. I think what has surprised me most is the importance of staying in touch with people who have inspired you, have caused me to think differently about issues. I have continued to, over the years, keep up with mentors, and the nature of our relationship changes so much as I gain experience, as they sort of evolve their views. It has been fantastically interesting to stay in touch and to see how relationships evolve as the industry evolves, as being an antitrust lawyer becomes totally different.
That's wonderful. And it's been wonderful having you on the program. Thank you so much.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.